Imagine this for a moment. You're in a busy clinic, could be A&E, could be a GP practice, and a child, maybe 7 or 8 years old, just leans in and quietly says, "Mom's boyfriend hits me when she's at work."
Mm-mm.
And you know their caregiver sitting right outside that door. I mean, that's not just a tough moment. That's immense pressure.
It's one of the highest stakes situations any clinician can face. Suddenly, you're the one who has to make the critical decision. This isn't just about medicine anymore.
Okay, so let's unpack this. Our sources today give us a really clear GMC-aligned roadmap for these moments. We're going to do a deep dive into child safeguarding, the recognition, the referral, and the documentation.
Yeah, and it's so important because this isn't about ticking boxes for an exam. It's about timely intervention. We want to get you from being, just aware of this to being expertly prepared.
So our mission today is to really distill those key actions that protect the child and make sure that you, the clinician, act lawfully. And it's all anchored by one mindset, right?
Believe, protect, record, refer. That's it.
Okay, so let's start at the beginning, the foundation.
Well, what's interesting is how safeguarding is actually defined. It's not just about reacting to abuse, it's proactive. It's about protecting children from neglect, from exploitation, and making sure they grow up in, a safe and effective environment.
And the legal anchor for all of this, that's the Working Together to Safeguard Children 2023 guidance, isn't it?
It is. That's the key document, and its main driver is pushing for a child-centered and, crucially, a multi-agency practice.
A multi-agency. So you're not meant to be handling this alone.
Never. The whole point is that we all have a duty to recognize concerns, share information, and refer. You're part of a network.
So let's talk about the thresholds for action. On the front line, what do S17 and S47 actually mean? When do I need to pick up the phone?
Right, so these are the legal triggers. The big one is S47. A referral is needed if you have reasonable cause to suspect a child is suffering or is likely to suffer significant harm.
Significant harm. That's the high bar.
That's the high bar for immediate intervention, yes. And the other trigger is S17, which is for a child in need.
And that's for less acute things.
Exactly. This might be where a child's health or development is being impaired, maybe due to poor care, neglect, that sort of thing. But here's the absolute key takeaway. For S47, you act on reasonable suspicion.
Not certainty.
Not certainty, and definitely not proof. Your job isn't to prove abuse, it's to report the risk.
Okay, but that distinction can feel really tough in a busy clinic.
Yeah.
How do you justify escalating a concern about a withdrawn child to significant harm without hard evidence?
You don't have to. You're not diagnosing abuse. You're identifying the risk and passing it to the experts at children's social care. You just need to know the red flags.
Like what?
Things like injuries that don't match the story you're given, developmental delays, or, of course, a direct disclosure from the child.
Is there one red flag that's an absolute non-negotiable, must-refer today situation?
Yes. The sources are crystal clear on this. Any bruise, any mark, any injury at all in a premobile infant, a baby that isn't crawling yet, requires an urgent pediatric assessment and a same-day referral, full stop.
Because there's no way they could have done it to themselves.
Exactly. Any injury is inherently suspicious of being non-accidental.
That clarity is really helpful. Okay, let's move from spotting the problem to taking action. The sources have this first, next, last framework. What's the absolute first step?
Immediate safety, step one, always. Before anything else. If the child is in imminent danger, the abuse is happening right now, or they're about to be harmed, your first action is 999.
Contact the police.
Contact the police. And at the same time, you're telling your senior clinician or your safeguarding lead, you must not try to investigate this alone.
So once safety is sorted, you might need to talk to the child. That's a delicate conversation. How do you handle it?
Very carefully. Step two is gathering information.
Yeah.
And you have to see the child alone. That is essential. But, and this is critical, you have to manage their expectations about confidentiality right from the start.
How do you do that without scaring them off?
You use a simple phrase, something like, "I really want to help you, but I can't keep secrets if someone is unsafe. I'll need to share this, but only with people whose job it is to keep children safe."
And I guess you can't ask too many detailed questions, right?
You can't. You are not a forensic interviewer. Asking detailed leading questions can actually contaminate evidence for a police investigation. Your job is to listen, reassure, and record exactly what they said, verbatim. The specialists will handle the rest.
Which brings us to the referral itself. Step 3.
The referral. And promptness here is everything. You must contact Children's Social Care or the MH team, the multi-agency hub, on the very same day.
The same day.
The same day, waiting for tomorrow or waiting for a colleague's opinion? Those are massive traps. They show you're not prioritizing the child's safety.
Okay, here's the bit where I think a lot of people get nervous. Consent. The sources spend a lot of time on this. If I suspect the parent is the abuser, do I really need their permission to call social services?
This is the central truth everyone must know. No. You do not need consent to share information for safeguarding if there's a risk to the child.
But what about GDPR? Patient confidentiality.
It's a valid concern, of course, but the law and GMC guidance are built for this. There's a clear lawful basis to share. It's usually the public interest test. Meaning, the duty to protect a child from significant harm outweighs the duty of confidentiality to the parent. It becomes necessary and proportionate to share that information.
So an exam option that says, discuss with the parent and seek consent before referring? That's probably wrong.
It's often the lowest scoring answer you could pick, especially if talking to the parent could put the child in more danger or lead to them, disappearing before an assessment can happen.
So the rule is to share lawfully.
Exactly. Share what's necessary, use secure channels, and, this is important, document your rationale for sharing without consent in the notes.
Okay, let's talk about the notes. That record is so important it could end up in court. What are the non-negotiables for good documentation?
It's foundational. First, verbatim quotes. Put exactly what was said in quotation marks. If you're noting injuries, use a body map. Describe them objectively, size, color, location.
And no opinions.
Differentiate fact from opinion, always. Don't write, the mother seemed careless. Write, the mother stated she could not recall how the child sustained the injury. It's factual.
And timing. Does it have to be done straight away?
It has to be contemporaneous. Write the note immediately after the event. Note the time of the disclosure, the time you called your senior, the time you called MSH. Vague, late notes are a huge pitfall.
Okay, let's try and make this stick. The sources gave a couple of good mnemonics.
Yeah, they're really helpful. For the key actions, remember the 3 Qs. Quote, verbatim, quick referral, and quietly share, which means on a lawful basis.
I like that. Quote, quick, quietly. And there was a second one, a framework for the whole process.
That's RAPID, it stands for. Recognize the risk. Act by referring. Protect the information. So share it lawfully. Involve your safeguarding lead in CSC and document verbatim.
RAPID. That covers all the bases. Okay, so based on all that, what are the most common traps we need to watch out for?
They almost all involve delay or trying to handle it alone, so waiting for proof before you refer.
Big mistake.
Huge. Or promising a child absolute confidentiality, you just can't do it. And a really dangerous one is discussing the concern with the alleged perpetrator before you've spoken to social care.
And what about an admin trap?
Using your personal WhatsApp or a private email to share details, that's a major breach of confidentiality. You must use secure, professional channels.
So the golden rule is always protect, refer, record.
That logic has to supersede everything else. It beats watchful waiting every single time. If you're ever stuck, just pick the option that protects the child the quickest.
Right, so we've covered the roadmap. Ensure safety, see the child alone, refer same day, share lawfully without consent, and document everything. That's the protocol.
It is, and if you're revising for exams like the MSRA, it's really worth checking out passthemsra.com. They have a lot of great resources that break down this kind of step-by-step logic.
Okay, so to leave you with one final thought. The sources briefly mentions some really complex scenarios like perplexing presentations or FII fabricated or induced illness.
Yes. That's when the concern is that the caregiver is actually generating the illness in the child.
It completely flips the dynamic, doesn't it? The person bringing the child for help might be the cause of the harm.
It does, and it raises a really tough question. How do you balance that duty to believe the child and protect them with the duty to investigate without bias when the caregiver is the focus of the suspicion? It requires extremely careful handling.
That's a really complex area, but I guess the foundation we've covered today, protect, refer, record, is exactly what you need to navigate even those situations.
It's the starting point for everything.
Keep learning, and we'll catch you on the next deep dive.